Nice.
On this week's episode of the Crushing Debt Podcast, Student Loan Solutions. So, welcome back to this week's episode. My name is Shawn Yesner, owner and founder of Yesner Law. And unfortunately, we are missing George again this week, but I know that he is listening to the episode. And so, George, welcome back last week. And George, we will see you next week. But as we've been teasing for the last couple of weeks, we have a really great show for you this week. I've got on the show my colleague, my peer, my friend, Jeff Hakanson. He has been an attorney now for 30 years, graduated from South Texas College of Law. I know that when I started in bankruptcy court, Jeff was already a fixture there. So he's got a little bit more experience than me, but he's got some particular experience lately in eliminating student loans. So first of all, Jeff, welcome to the show.
Thank you very much, Shawn. I'm glad to be here. Look forward
So
to it.
yeah, so I think we're going to have a good time. And I think this came out of a hearing I was in that, you know, the old guard in me says student loans are typically non-dischargeable. But we now have a way to make discharge easier, if I'm understanding correctly. Because before
Yeah,
we used to be under the Brunner test, or we could discharge student loans if we could prove that the debtor in bankruptcy court had some type of hardship. So why don't you talk a little bit about what is the Brunner test and how did it apply? And then after that, we can get into maybe some of the changes that are going on in court so that we can actually help people who are in bankruptcy who meet the requirements to maybe get rid of their student loans.
all right. So the Brunner test, for all intents and purposes, in today's presentation and discussion, it still is the law of the land. Okay, and under the Brunner test, you had to demonstrate that the borrower has some type of undue hardship that's likely to last throughout the repayment period, and that the debtor has made good faith efforts to try to pay the loan. Historically, that was an insurmountable burden. I tried cases from both sides over the years, back in the early 2000s, and it ended up with the judge splitting the baby, oftentimes. But the standard really was never met, and any relief that we found was under like Section 105 equity jurisdiction, and but it never really provided any relief to the debtors.
Well, undue hardship tended, in my opinion, the way that I had described it to clients or potential clients, undue hardship typically was medical related. I remember once a realtor that had some degenerative eye disease and went blind. Well, how are you
Mm-hmm.
supposed to drive people around to their listings if you can't see to drive?
Yeah,
It always appeared to be more of a medical hardship than anything else.
I think that's correct. It usually was something beyond the debtor's control that was, even if it was extreme, like a blind paraplegic, you still couldn't demonstrate the fact that the hardship would last throughout the repayment period, and that it was likely to persist through that period. It just was an impossible standard to meet. And it's very expensive. You have to bring in experts. You got to have a doctor. You got to have medical files. Um, the student loan servicers usually engage in pretty lengthy and aggressive discovery and litigation, and never really try to work anything out because they're in the catbird seat. They're sitting on a non-dischargeable debt, and an extraordinarily, if not nay, impossible burden to meet in order to get any relief from those student loans. It
So
was impossible.
so what happened? What changed?
What changed was on November 17th, 2022, the Department of Justice issued a memorandum on student loan discharge, and basically it rewrote the standards for the Brunner test and the totality of circumstances test. Those are the two different tests for discharge of student loans. And what they did was they created a simple, non-adversarial process for presenting the relevant information with regard to undue hardship, whether economic, obviously the economic aspect of it, but also the personal life story part of it, and a demonstration of good faith efforts to repay. And that was put together in a 40-page memorandum that goes through the Brunner test and how it's going to be dealt with with relaxed standards.
So what are the relaxed standards? In other words, if I'm a student loan borrower and I find myself in bankruptcy, what are some of the signals or signs that maybe I am eligible for a student loan discharge?
The first thing you're going to look at are the presumptions that are provided in the new guidelines. And the presumptions are that any debtor who's over the age of 65, it's presumably dischargeable. Disability or chronic injury, if it can be demonstrated, and not as extreme and draconian as the classic blind quadriplegic. A significant disability that would, like you said, lead to an inability of an Uber driver to drive. Got to demonstrate unemployment, or you can demonstrate unemployment for 5 of the last 10 years. That gets you in the door. And that the loan has been in a repayment status the last 10 years. That's been a little bit goofy and wonky lately. Department of Education has come up with some inconsistent results as to how they calculate those 10 years and whether it tolls the 10-year period if you're in a forbearance or something like that. But usually you can navigate around that. The good faith aspect, is these are easy to meet. The good faith aspect is really simple to meet. You can demonstrate it by making a payment. That's it, making one payment. Applying for a deferment or forbearance. So that brings the forbearance and deferment into play. Apply for what is known as an IDRP or an ICRP, income contingent repayment plan. Now, some of those, the most recent plans, such as SAVE and PAY, those are the acronyms describing the plan, are up before the Supreme Court as to whether those approaches can be made. But right now, it's the law of the land. You can respond to and engage with a servicer, or engage meaningfully with a third party. That's having a conversation with your lawyer. And then the financial aspect of it is pretty interesting. It really just boils down to a submission of what you put in Schedules I and J. Because again, this all has to flow out of a Chapter 7 or a Chapter 13 bankruptcy case. Okay, it's not the forgiveness that you hear the talking points on television about different programs to forgive loans. That's not going to happen. This remedy is available because it's individual. It requires the filing of a bankruptcy, which puts the debtor on, I guess from the department's point of view, on a more solid footing for discharge and some type of relief. So those are kind of the buzzwords and the standards that you look for when you're talking to a client when they come in. And the next thing that I think to talk about would be the process. How does it work?
So before we get there real quick, I seem to recall, because admittedly, it's been a while since I've tried to discharge a student loan in bankruptcy, although maybe I'll focus on doing that going forward. But one of the things that I thought I had remembered, and you can correct me if I'm wrong, that our judges in Tampa, in the Middle District of Florida, our judges wanted to see that you had made some effort with your budget. In other words, they were not too inclined to discharge a student loan if you had, for example, I'm going to make an extreme example.
Yeah.
You had a $1,200 car payment and you didn't do anything to see if you could get into a new car and reduce that car payment. Or if you had a Netflix subscription and an Amazon subscription and a Google subscription and a this and a that. They wanted to see the debtors make an effort to cut other expenses to see if some money could be freed up. And if there was still that hardship, then they would be more inclined, assuming the other factors there were present. Am
Yeah.
am I right on that? Am I missing the
I think
ball
you're
there?
on point on it. And it had to be something substantial to be demonstrated, and it was also often very hard to do that. But they wanted to see that you are maximizing your income and minimizing your expenses. In order to get into the door, that was kind of a hallmark of the analysis for the bankruptcy judges.
Okay. So how does the process work now? I know you got to file an adversary, which is a lawsuit within the bankruptcy.
That's correct. Yeah. So we're going to file an adversary proceeding for undue hardship to demonstrate undue hardship, and we're going to serve the Department of Education. The Department of Education deals with they may have a servicer, but they actually own and hold all of the federal student loans. And that's what these refer to. Private student loans are a different deal altogether. They're still under the same standards. But with this, we filed a lawsuit. Once you serve it on the Department of Education and the Assistant United States Attorney, they provide what is called a litigation package. It basically comes from studentaid.gov, but it also contains all of the information about the loan, the payment history, the loan documents, attempts to work something out, forbearance, deferment, all of that. It's basically the servicing file on each particular loan. So that information comes to you from the Department of Education. That allows you to fill in the blanks, so to speak, or fill out the form. It's a form-driven process. Then the form that is vital to this process is what's called an attestation. It's a lengthy affidavit where you swear to your financial and physical conditions. The first part is basically taken from Schedules I and J, and how those numbers compare to the IRS standards for those types of expenses. The next part involves the efforts that you made to repay, like we discussed earlier. And then there's a series of places, about 3, where the debtor can tell their story. It gives them an opportunity to be, and I encourage you to say, write as much as you can and as much as you want. Tell your story. This is your chance to, this is going to be reviewed by a judge, but it's not going to get there from a litigation standpoint. So what's interesting about that is the debtor has an active part in it rather than the esoteric aspects of litigation and discovery and all of that. They get to have their day in court, so to speak, or explain their circumstances. And so that is prepared, filled out, notarized, and sent over to the Department of Education through the AUSA. And then they consider it. They make a determination whether it warrants a discharge or not. And they can even and they've offered in a few of these cases, well, the numbers come out a little bit different. I think that they can afford to do this reasonably going forward with some success and longevity. Therefore, we'll give a partial discharge. Okay. So that's the process. If the determination comes back, yep, it's good for discharge, it meets the new standards, then they'll send a recommendation. Department of Education will approve it, and you paper it up with a stipulation of facts, judgment of dischargeability, and we never would have gotten there without this new process. It's very simple, non-adversarial. It goes pretty quick. At the beginning, they were overwhelmed with the influx of these cases. I think some guys got frustrated and got out of it, but it's really not that hard to do. And like I just described, that's a 2 or 3 month process right there, and it's easy. Not You don't have to track down the information; it's provided to you,
Wow.
and then you just synthesize it into a story of undue hardship, both financial and actual, and it's likely that you'll get a determination of a non-dischargeability. First case out of the gate, we got a discharge for a woman who had $344,000 in student loan debt, and they
Wow.
gave her 100% discharge.
What was her profession?
She was trying to be a lawyer, but she had gone to med school before that, and then there were a number of like immunological syndromes that she had that limited her ability to do certain things. A legitimate medical hardship,
Yeah.
but not overwhelmingly. I mean, she could still get around. She was trying to get a job as a lawyer. That would never fly 10 years ago.
Right.
You know?
Well, and
I mean, you can't walk into bankruptcy court as a lawyer and try to discharge your student loans. It's just not going to fly. Now,
right.
now it will, and it's a viable process. Like, I've probably done a dozen and a half of these cases and gotten discharges on at least half of them. And the other ones, they really weren't undue hardship. So
It's interesting. It's ironic, I think, that it's non-adversarial, but in order to do it, you've got to file an adversary proceeding. But so if I'm a debtor and I'm looking at getting my student loans discharged, I assume there's a cost to file the adversary proceeding.
mm-hmm.
Are there typically, and again, I don't want you to give away your secrets, but I would assume
debtor's filing fee for an adversary in that situation is waived.
Oh, really?
Yeah, that's a nice little nugget for them. So.
Are there attorney's fees?
Well, no, because you're basically settling the case. It's not a prevailing party situation under a contract or a statute. If Judge McEwen has intimated that attorney's fees are in play if you bring this in front of me in trial, and while the new guidelines aren't the law of the land, she said, it would likely be, upon proper record that she would enforce or implement or use these guidelines. And, if you take it to trial, she intimated that she would award attorney's fees.
Oh, which makes sense. I would assume all student loan contracts have a prevailing party attorney fee provision to them.
Yeah.
But is it something that if I'm the debtor, is it something that I would have to be prepared to pay my attorney not only the fees and costs of filing the Chapter 7, but an additional fee to bring the student loan discharge action?
Well, you got to be a little bit creative in how you bill things out. At the beginning, I was all full of the veritable blank and vinegar, and fired up to run these things through. And when I read this memo when it came out, I was like, "Holy cow! I want to run this one up the flagpole and see what happens, man." So I think we took that case on a pro bono case, and then we started to figure out what kind of volume may exist, and it's not really something you can develop a practice with, but the need is out there. So what we've come down with is attorney's fees for the main case, and then we were charging about $2,000 for the adversary.
Okay,
and it's really not that much work. $2,000 to $3,500, depending on how much was in play, and we tried to work. What's good about it is you can still take payments while someone's in a Chapter 7 or after discharge. So we would give them payment plans if they wanted to do that. You got to be a little creative in doing something, but the price range is $2,000 to $3,500, I would think. And in some discussions with the chief judge about how these cases move through, an indication was made that the judges in Middle District Tampa would award $3,500 as a presumptively reasonable fee.
Wow. Okay.
So you can make money on it, and it doesn't require that much work. It's not the lengthy discovery. The discovery is provided to you out of the chute.
Remember, you're on a podcast that's going to be out there, so don't admit that it's not a lot of. You should be saying it's a ton of work. We deserve more than the.
Yeah, well, you know.
Do you happen to know? I mean, we're here in Florida. We're here in the Middle District. I know that Brunner was not necessarily the test countrywide,
No.
but it sounds like the Department of Justice memo would apply. So do you know how this interacts in places that don't necessarily rely on Brunner?
Then there would be totality of the circumstances. And again, the totality of the circumstances are reviewed in the presumption, the good faith, and the financial disclosures.
Okay.
It's gonna be the same thing. It's a relaxation of Brunner and a relaxation of the totality of the circumstances test.
So I wonder what that means for. I wonder. I don't want to get too much into politics, but
yeah, go ahead. It's a big part of it.
But I was going to say, I wonder how much of this was in response to President Biden wanting to forgive student loans. I know the Trump administration, both before and after Biden, has said some stuff on student loans. I wonder how much of this was a reaction to that. In other words, I wonder how much the Department of Justice said, well, let's relax the requirements so that we don't have President Biden pushing forgiveness as much as he has been, or maybe 10,000 of forgiveness versus 50,000 of forgiveness. Let's relax the circumstances. I wonder, not that I'm complaining because it appears to be a good thing, but I wonder how much of it is rooted in sort of the political game.
Well, the way that I've seen it, and I've paid attention obviously to it because I'm engaged in the issue, and it seems to me that a lot of in both parties are kind of interestingly enough aligned on this type of relief, but there's also political talking points that come from that deal with the issue of forgiveness. I think a lot of that stuff has gone through the Supreme Court and may still be up there, but the forgiveness issue is just political talking points. You can't paint with such a broad brush that you're dealing with a whole group of people. Everybody who is a firefighter is entitled to a discharge now. You can't do that. But what both sides, both parties, and both administrations kind of acknowledged was, hey, if this is somebody who's in bankruptcy, they're involved in a true litigation situation. They're in a lawsuit. It's a one-on-one thing. It's not painting with a broad brush. It's not a class action lawsuit or anything like that. It's one individual going through the litigation process. And with this, it really doesn't run afoul of either party's positions or thoughts about it politically. So they don't really object to that aspect of it.
Okay. Anything else that we need to know? I mean,
it's just it's a little bit invigorating. It's fun to get one of it's almost, I don't want to overstep it, but it is nice to get somebody relief like that. I was on my way home and stopped at the grocery store, and I heard a Mr. Hakanson. And it was one of my clients that I had dealt with. And odd coincidence, like a day earlier, I had gotten the email from the assistant U.S. attorney saying that they had allowed her or made a determination that her loans would be fully discharged. And I was like, oh, I meant to call you, but I was waiting to get it in writing or whatever. But, and I told her what happened, and she literally fell to her knees crying. And I'm like, hey, come on, stand up. You're making a scene here.
right.
That doesn't happen too often when you're handling cases like this. And what I mean is you can these are good cases to get the juices flowing again, to see how the process works, to experience a litigation process that is non-adversarial. I can. It's difficult to describe that, but the level of collegiality, professionalism, and courtesy that the AUSAs and everybody practices with in connection with this process, and the judges' sincere interest and intrigue about the process is fun. And like I said, invigorating.
Yeah.
I would suggest any of the guys who are doing this to take one up. It's not going to tax your time too much, and you might just hit a home run. It's very likely that you'll hit a home run. And I'm happy to give my input to anybody who gets caught in the process and says, "What do I do now?" We put together a model to push these things through, and I'm happy to share it with anybody who gets a case and wants to try it.
Yeah, no, I appreciate
And I
that.
didn't mean that word. That was the improv. It's not a trial. We're not trying anything. We're just
Right.
giving an attempt. So.
No, I understand. I understand. And that's maybe a good lead in. So one of the things I failed to do in your introduction is tell people where you are. So you are working with our friend Jake Blanchard over at
Yeah.
his law firm. I think the website is jakeblanchardlaw.com. And I know your email address is Jeff, Jeff, at jakeblanchardlaw.com. And I know Jake has been a really good friend of mine and colleague of mine, going way, way back. He's been doing bankruptcy for, who's been practicing longer, you or Jake?
I've got a couple of years on him.
Okay. Yeah.
He's
I think
about the same time as you.
Yeah, I think he was just about the same time as me. But yeah, I mean, if you have questions, if you're listening and you have questions about your discharge, you can always contact Jeff at his office, and he can answer questions. Now, if you're already with another attorney, I know I personally don't like to necessarily Monday morning quarterback, but if you are not connected to an attorney and you have questions, Jeff at jakeblanchardlaw.com, I'll put that in the notes. Anything else, Jeff? Anything else we're missing? Anything else you wanted to say?
No, I mean it's evolving, but not dramatically or drastically. Under the right situations, it works, and it's manageable, and it engages and includes the debtor in the process, which is a wonderful exercise, to actually let the client think that they've got a say in things and how it's presented to the judge. So it works. It's no longer that there's no way you can discharge student loans. You can right now, and neither side is really looking as a political matter to change this process. I think it's been 3 years now almost, so I think the process is going to remain.
Yeah, and it's about time. I mean, student loan costs are kind of getting out of control, I think. And so, the whole purpose of bankruptcy is for those people that find themselves in circumstances that they can't afford to pay back their debt. And that includes student loans. And I get both sides of the argument. You got the education, you borrowed the money, you should pay it back. I understand that.
Yeah.
But at the same time, good people find themselves in bad situations, and that's what we're here for.
Yeah, and it's an individual analysis. It's not a blanket application to a particular group, teachers, nurses, anything like that. It's a case by case, debtor by debtor, facts and circumstances specific to that debtor, which is fair, which is absolutely fair.
And I assume the same stuff still applies. So if somebody qualifies, for example, a PSLF forgiveness, or if they do qualify for an income-driven payment plan or something, those strategies to handle your student loans are still in place.
Yes.
Okay.
Yes.
Well, very cool. Thank you. I appreciate you being a guest on this week's show.
It's a pleasure. I really enjoyed it. Thank you for giving me the opportunity.
A couple of things to wrap up with here. So, we do mention we've got the video here of me and Jeff. And so if you want to see that, you can always get it behind the paywall at patreon.com/crushing debt. If you want to help me pay off my student loans, again, I'm kidding. The money we get through Patreon goes back into the show. Yeah, other than that, Jeff, we really, really appreciate it. I mean, student loans are a big issue. Like I say at the end of every episode, hopefully this episode and all the other content we have on our podcast helps you have more money at the end of the month rather than month at the end of the money. And we will talk to you in next week's episode.
Hey, thanks a lot. Take care,
Thanks,
Shawn.
Jeff.
Bye-bye.